You're watching the legal breakdown. So, Glenn, we've got some news here with major implications for Trump's classified documents case. He reportedly wrote to-do lists for his assistant, Molly Michael, on White House materials with visible classified markings on them, because apparently one man's classified documents is another man's post-it notes. Can this be used against him in his federal trial in Florida?
Oh, it can be and will be. And this reporting is jaw-dropping because this former executive assistant, Molly Michael, who reportedly was with Trump since 2018, transitioned with him down to Mar-a-Lago when he left the presidency. Boy, there is some blockbuster evidence that we are now learning about that she provided to the FBI and to the federal prosecutors. For example, when Donald Trump knew that the FBI was going to be interviewing Miss Michael about the boxes, she quotes Donald Trump as telling her, "You don't know anything about the boxes." If that is not some straight up mob talk, I don't know what is, but it is so deeply incriminating.
Now, I want to focus on that moment in particular. When Trump did tell her, "You don't know anything," could that moment in particular, what could that moment in particular mean in this trial?
You know, it means so much to prosecutors, Brian, because one, it shows that Donald Trump knew what he was doing was wrong and he was trying to cover it up. Not only was he trying to cover it up, which proves his consciousness of guilt. There can be no mistaking that he thought he was lawfully possessing these government documents, because if he was, he would not have had to tell his executive assistant, "You tell the FBI you don't know anything about the boxes." But it is an incriminating twofer because it can also serve as the basis to bring a witness tampering charge. Now, we don't know if additional charges will be added by Jack Smith, but it sure feels like they could be based on this evidence, this revelation. Because when you tell a witness who is about to be interviewed by the FBI about your crimes, don't tell them what you know. That is heartland witness tampering. So, whether we will see more charges brought or whether Jack Smith will just exploit this directly incriminating evidence at trial remains to be seen.
Well, it's clear that this would be directly incriminating evidence, but I guess how admissible is everything? Because, it in what sense is this just her word against his? Or on the flip side, is this a home run? Because when you have a witness with firsthand testimony, you assume in trial that they're telling the truth and you defer to what they're saying.
Yeah, this is, if not a home run, it's a pretty strong triple. It's probably an in the park home run, because when you have a witness with no apparent axe to grind against Donald Trump. I mean, she left with him from the White House. She continued to work for him down at Mar-a-Lago. Doesn't seem like she's an angry Democrat, as Donald Trump is always calling his critics. And that person provides direct, firsthand, incriminating information out of the mouth of the defendant. I think we toss around the term he said, she said. First of all, in Donald Trump's trial, there will be no he said, because he cannot testify. If he testifies, that would be the final nail in his coffin with respect to guilty verdicts. So it will be she said, and he is not even going to be in a position to rebut it. Now, his attorneys might try to knock down her credibility by digging up whatever dirt or manufacturing whatever dirt they might be able to find on Miss Michael. But boy, it feels like it is so corroborative of so much else we know that, it just sort of builds on itself. There are other statements that are related in the reporting, like Donald Trump telling her, "Listen, you need to help spread the word that there are no more boxes." And Ms. Michael said, "But there are more boxes. And lots of people here at Mar-a-Lago know it, Mr. President." So, this is so dramatically incriminating. And if Miss Michael proves to be, a credible witness, a reliable person when she's testifying, this is devastating.
Just kind of building on that a little bit, can you explain what hearsay is? Because I feel like there's a lot of misconceptions about when you can believe what someone says and when you can't.
So hearsay is technically defined as an out-of-court statement, that means a statement made out of court, that is introduced as evidence in court to prove the truth of the substance of the statement, right? So let's run this to ground. If I were to testify about what other people said outside of court, I would not be allowed to offer that testimony because it would be hearsay, with one important exception. Anything said out of court by the defendant who is on trial is non-hearsay. It's an exception to the hearsay rule. It's called a statement of a party opponent. So anything Donald Trump said outside of court, a witness like Miss Michael can come in and testify about it, and it is not hearsay. However, an important footnote to that, Donald Trump's lawyers cannot introduce into evidence his statements. That's defined as hearsay. It's only when a party opponent, in other words, the prosecutor, tries to put the statements of the defendants into evidence, that it is non-hearsay. That is a real benefit to the way the rules of evidence are drafted. And that's why everything out of Donald Trump's mouth that's incriminating can be introduced as evidence by Jack Smith, but nothing that he says that is exonerating, that is helpful, like I declassified documents with my mind, none of that can see the light of day inside the courtroom because his attorneys aren't allowed to present it.
So when Molly Michael comes into court and kind of reveals what Donald Trump said to her, does the court assume that she's telling the truth because otherwise she would be opening herself up to perjury charges?
The court assumes nothing about the credibility of witnesses. It is completely within the province of the jury to make credibility assessments. They will eyeball every single witness. They'll assess what they're saying. They will watch their demeanor, their body language, the way they communicate. They will see whether what they're testifying to is supported by or contradicted by other evidence, written communications, emails, text messages, and prior statements that Miss Michael may have made. For example, if she confided in a friend after Donald Trump told her, you don't know anything about the boxes the FBI is about to ask you about, that statement that Miss Michael makes, if her credibility is attacked, it can come in as a prior consistent statement. That's another exception to the hearsay rules. There are as many exceptions as there are prohibitions to the hearsay rules. So, no, that is entirely up to the jury to make that call. Either a witness is credible or is not credible. Either they're going to use their testimony to convict the defendant, or they're going to discard it because they don't believe that the witness is telling the truth.
Okay. And it's sad that I have to ask this, but is there any way that Judge Cohen could mess with Molly Michael's ability to testify so as to help the Trump team?
Based on the reporting we know about Miss Michaels, what she said, her status as a Trump executive assistant, there is nothing Judge Cohen can do to shut down the testimony of a witness who has sharply incriminating statements by the defendant who is on trial. I know we are all apprehensive about the way Judge Cohen might insert herself into the trial to Donald Trump's advantage. Goodness knows she's done it before, but there really is nothing that she can do to shut down the testimony of Miss Michael.
And as of right now, I know that another issue for everybody is that we're expecting to see more delays happen in this trial so as to push that May 2024 date farther out. Is there anything that would suggest that we will see a delay in this trial as of now?
I do have the sense, based on the reporting, that Judge Cohen has been slow walking some of her rulings, but thus far she has not tried to alter the May trial date. So, as of right now, it's still on track to go to trial in May. Again, if I had to bet my dollar, that's my betting limit, I'm not a high roller, I would probably put the buck on the trial date slipping, not actually proceeding in May, but Judge Cohen finding reasons to grant motions to continue the trial date, which will inevitably be filed by Trump's team.
Okay, and finally, let's end with this. You did bring up the idea of Donald Trump testifying at this trial. Do you expect that Donald Trump would be well served by testifying at any of his impending trials?
No, Donald Trump cannot be placed under oath, swear to tell the truth. I mean, after being asked his name, I would be dubious about whether he could answer any other question truthfully. We've seen some snapshots, right, of deposition testimony that he's given previously, and it's been an absolute train wreck for him and his credibility. So I don't think, and I think he's a coward at his core. I don't think there's any way he's going to want to sit up in front of 12 citizens sitting in a jury box as the conscience of the community, judging his credibility. Because I got to tell you, Brian, cross-examination by a prosecutor of Donald Trump would be the highlight of that prosecutor's career. And I think any prosecutor would do it for free if given the opportunity.
And you look at how he incriminates himself even when he's not on trial. I mean, he spoke with Meet the Press this weekend, and he said it was all his decision to move forward with all of the events that he's currently on trial for in Washington, D.C.
He actually took away a defense he might have otherwise had.
Was that the advice of counsel defense?
It's the advice of counsel defense. It's a beautiful thing. He could have said, well, I was relying on the advice of counsel when I, bought into the fake elector scheme, or when I was being told that the election was rigged and that there was lots of fraud undermining the election's results. And when I was being told that Mike Pence really had the constitutional authority to just toss out the electoral votes and install me for a second term. I was just relying on the advice of counsel, what my attorneys were saying. And I use a more relatable example of if I'm filling out my tax returns and a tax attorney or a tax preparer says, yeah, Glenn, you can take that deduction. So I do. And then the IRS comes calling and they say, Glenn, you're not allowed to take that deduction. What do I say? Advice of counsel. My tax lawyer, my tax preparer told me I could. That is actually a legitimate, viable defense in the criminal law to some offenses. Donald Trump went on air with Kristen Welker and said, I wasn't really relying on counsel. I was relying on my own instincts. Well, guess what? There's no such thing as advice of your own instincts defense. So Donald Trump just took away another potential defense his lawyers might have been able to use at trial.
And something tells me it's not the last one. So for anybody watching, we'll obviously stay on top of this stuff. If you want to stay on top of everything as soon as it breaks, make sure to subscribe. The links are right here on this screen. I'm Brian Taylor Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.